Hi and welcome back to the Freedom Law Group Law Library. This is part 2 of a 10-part series showing all the many evidences and undeniable proof that the revocation of election process is legitimate and your legal exit from the federal income tax system. In video 1, we talked about how there is no law requiring American nationals, those born or naturalized in the 50 states, or to a parent who was, to file and pay a federal income tax. These American nationals, who comprise 98 to 99% of the population of the United States of America, have always been protected from the federal income tax by Article 1, Section 9, Clause 4 of the Constitution, and multiple Supreme Court decisions. If you haven't seen video 1, be sure to go back and watch it now so you have the proper foundation to continue through this series. In this video, we're going to answer the first 2 questions this raises. 1. How did Congress and the IRS get away with writing and enforcing laws that appear to violate the Constitution? 2. How did they convince people to file and pay when they were never legally required to? And 3. If there's no law requiring most Americans to file or pay, how does the IRS get away with pursuing, prosecuting, and intimidating people into compliance? We're going to answer the first 2 questions in this video, and we'll answer the third in video 3. And we're also going to give you the smoking gun, the absolute undeniable proof that the federal income tax system is not lawful in the 50 states of the Union unless Americans voluntarily waive their constitutional protections by opting into the federal income tax system. We'll be talking more about this in the next video. The fact that the federal income tax laws were not written for the 50 states of the Union means there should be a lawful exit for those of us that voluntarily opted in unknowingly. And there is. It's called the revocation of election. But we'll cover that more in depth in later videos. Let's begin with question 1. How did Congress and the IRS get away with writing and enforcing laws that appear to violate the Constitution? The answer begins with this fact: the Constitution is not the law of the land in the federal territories. That might be surprising, but it's legally true, and it's the key to understanding how Congress pulled this off. When the founders wrote the Constitution, they created a compact between the several states and a limited federal government. The Constitution exists to restrict what Congress can do within the 50 states of the Union. But when Congress governs federal territories, like Washington, D.C., Puerto Rico, Guam, and other possessions, it does so under a completely different authority. That authority is found in Article 4, Section 3, Clause 2 of the Constitution. It's known as the Territorial Clause, and it gives Congress the power to, quote, make all needful rules and regulations, close quote, for the territories and other federal property. In those areas, Congress has what the courts call plenary power, meaning total legislative authority, not limited by the Bill of Rights or the structural restraints of the Constitution. In plain English, within the territories, like D.C., Congress can do things that would be unconstitutional in the 50 states. That includes creating laws that would violate due process, equal protection, or the apportionment requirements of Article 1, all of which normally protect Americans living in the states. This is the legal sleight of hand Congress used to get around the constitutional limits on income taxation. They wrote the Internal Revenue Code to apply only inside the federal zone, then redefined key terms like United States and state, to make it look like the law applied everywhere, even though it doesn't. Once you understand this, everything else begins to make sense. Congress didn't violate the Constitution, they avoided it, by legislating in a jurisdiction where it doesn't apply in the same way. And then they used semantic deception, a legal shell game, to get the American people to unwittingly step into that jurisdiction by filing a 1040 form and electing to be treated as a taxpayer. So what did Congress actually do? Again, they wrote the Internal Revenue Code to apply only within that federal zone, since it would be prohibited in the 50 states of the Union, and then redefined a handful of key words so that it would appear, to the average reader, as if the law applied nationwide. The central term is United States. In 26 U.S.C. Section 7701(a)(9), which governs income tax definitions, Congress wrote, quote, the term United States when used in a geographical sense includes only the states and the District of Columbia. Close quote. So according to this definition in the law, the United States only includes the states and the District of Columbia. Now, most people assume the term states means the 50 states. But in the tax code, Congress defined it to mean something entirely different, and it means only Washington, D.C. And that's how they enslaved the nation. Let's look at it in the law. Here's the statutory definition of the term state exactly as written in the Internal Revenue Code at 26 U.S.C. Section 7701(a)(10) quote, the term state shall be construed to include the District of Columbia, where such construction is necessary to carry out provisions of this title. Close quote. That's it. It doesn't say the 50 states are included. It doesn't name them. It says, quote, shall be construed to include the District of Columbia, close quote. And only where necessary to carry out the code. That means D.C. is being labeled a state for tax purposes, but the actual 50 states are nowhere to be found in that definition. And that's not an accident. When they say the term state includes the District of Columbia, and name nothing else, that's all it includes. Everything else is legally excluded by omission. To the average person, the word includes sounds like it means in addition to or among others. But in statutory law, that's not what it means, at all. In legal drafting, especially within federal statutes like the Internal Revenue Code, when Congress defines a term using the word includes and then lists one or two or more specific things, that definition is read as exclusive, not expansive. In other words, everything not listed is excluded. The 50 states are not included in this definition of the United States or states, which means the 50 states are excluded. This is settled legal principle in the law. In Meese v. Keene, 481 U.S. 465, 1987, the Supreme Court ruled, quote, when a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. Close quote. And in the same opinion, they made this even more clear, quote, it is axiomatic that the statutory definition of the term excludes unstated meanings of that term. Close quote. The court also affirmed this principle in Colautti v. Franklin, 439 U.S. 379, 1979, quote, as a rule, a definition which declares what a term means excludes any meaning that is not stated. Close quote. Let that sink in. If Congress gives a special definition, especially one introduced with the word includes, and it names just one or two things, then every other possibility is legally excluded. The courts are not allowed to fill in the blanks. Neither is the IRS. And neither are you. This principle of construction is so foundational, it even has a name in Latin. The maxim is, inclusio unius est exclusio alterius, meaning, the inclusion of one is the exclusion of all others. This is a guiding rule of statutory interpretation that has been cited for over a century. The Supreme Court referenced it as far back as Express Company v. Railroad Company, 99 U.S. 191, 1878, and it continues to be upheld today. So here's what this means for you. When Congress defines state to include the District of Columbia, but does not include the 50 states or name any of the 50 states, that's the end of the definition. The 50 states are not included, and courts are not allowed to pretend otherwise. When Congress defines United States in 26 U.S.C. section 7701, A9, as quote, including only the states and the District of Columbia, close quote. And states means only D.C., that means everything else, the 50 states, the republics, the sovereign land outside the federal zone, is excluded. These aren't theories. They're statutory facts. And once you learn how to read their language, and stop assuming that everyday words mean the same thing in legal code, you begin to see the deception clearly. Now let's compare that to the definition Congress used when they passed a completely different tax, the petroleum excise tax. This tax is perfectly constitutional and applies nationwide. And this is the smoking gun. In 26 U.S.C. section 4612, A4A, Congress defined United States this way, quote, the term United States means the 50 states. Close quote. There it is. In plain English. The 50 states. And the definition goes on to include the District of Columbia, the Commonwealth of Puerto Rico, any possession of the United States, the Commonwealth of the Northern Mariana Islands, and the Trust Territory of the Pacific Islands. Again, that's the smoking gun. When Congress is operating on constitutional ground, like with excise taxes, they define the United States to include all 50 states. But in the income tax code, they don't. Why? Because they can't. The Constitution forbids them from imposing a direct tax on the people of the 50 states unless it's apportioned. And the income tax is not apportioned. This was confirmed by the Supreme Court in Pollock v. Farmers Loan and Trust Company, 1895, where the court struck down a federal income tax for violating Article 1, Section 9, Clause 4 of the Constitution. And this decision has never been overturned. Not by another Supreme Court and not even by the 16th Amendment. By the way, for an in-depth look at the problems and limitations of the 16th Amendment, be sure to watch the video on our channel about the 16th Amendment. Continuing, rather than apportion the tax, or pass a proper amendment to expand their power, Congress simply redefined the jurisdiction of the tax. They wrote the income tax laws to apply in D.C. and federal territories, and then let the public assume the law applied to them. It gets deeper. You are what we refer to as an American national. But in the language of the Internal Revenue Code, you are actually classified as a non-resident alien. And here's why. According to 26 U.S.C. Section 7701, B.1b, the term non-resident alien means, quote, an individual who is not a citizen or resident of the United States. Close quote. Well, we already know that United States in the Income Tax Code means D.C. So if citizen or resident of the United States refers only to someone domiciled in the D.C. or federal zone. If you were born in one of the 50 states, or you live and work there and are not a federal employee, then by definition, you are not a citizen or resident of the United States. You are a non-resident alien. Not an alien in the immigration sense. You are simply alien to the legal jurisdiction of the federal zone. You are alien to D.C. And here's the kicker, non-resident aliens are not subject to income tax unless their income comes from a quote, trade or business, close quote, within the United States. And remember, United States still means D.C. So if you don't own a trade or business inside D.C., you are a legal non-taxpayer, or at least you were before you filed your taxes. But again, more on that in video 3. But for kicks and giggles, let's take it one step further. So what is a trade or business? According to 26 U.S.C. Section 7701, A, 26 quote, the term trade or business includes the performance of the functions of a public office. Close quote. There's that word includes again. So the actual definition of trade or business is the performance of the functions of a public office, a federal or national public office. So if you're not performing the functions of a public office, you're not engaged in a trade or business as defined by the Internal Revenue Code. Which means you're not earning taxable income. This is a very important point because non-resident aliens are the legal non-taxpayers referred to in federal court rulings, like in Edwards v. Keith, 231 F. 110, 2 DCIR 1916, where the court said, quote, the revenue laws are a code or system and regulation of tax assessment and collection. They relate to taxpayers, and not to non-taxpayers. The latter are without their scope. Close quote. Non-resident aliens, that is, American nationals not engaged in federal employment or earning income from federal sources, have no tax liability. Again, at least, they didn't. Until they voluntarily elected into the system. That's what we'll explain in video 3, how simply signing a 1040 form waives your constitutional protections and converts you into a taxpayer under their statutory system. And how to lawfully revoke that election. That's it for this video. Be sure to like, subscribe, and turn on notifications so you don't miss the next video. This series is just getting started.